for those of you who are going to be appearing in the housing court, straggling is not a good thing. So, so this will be the exception rather than the rule. Usually they have the, Dave Grossman has the Harvard people dissent. There are a few. There are a few.
Oh, I see the one guy. Doing the training at Wilmer, and then another one at Boston, and I suggested that they all
Yeah.
to get it better. No, it's a better training. But
Yeah.
I listen, they go on for hours. They do it.
Yeah, exactly.
These were the flowers that Sarah sent.
My son baked me a cake from scratch.
That's sweet.
A chocolate covered.
Oh, gosh.
It was really sweet. I was like, oh, be sweet someday. I tried to model sweetness and generosity to her. It hasn't worked.
Well, this is the exception rather than the rule.
Oh, okay.
All right, want to get going?
Okay, I want to welcome you all here. My name is Joanna Allison, and I'm from the Volunteer Lawyers Project of the Boston Bar Association. And also from my office here is Hugo Nakai in the back. Hugo, if you can stand up and give a wave. Hi. We are the folks from our office, in addition to our bossy paralegal, who run the Attorney for the Day project out of the Volunteer Lawyers Project. So when you come to volunteer, we're the folks that you will see. We have a very good training scheduled for you tonight. I want to introduce our trainers. First of all, we have Judge Jeffrey Winnick from the Housing Court. He's the Chief Judge from the Housing Court, Boston Housing Court. First Justice, is that how I say that?
Whatever.
And I want to tell just a little recent story. I had gone into the courtroom after advising a couple of people who were going to be pro se, and I wanted to see how things went. And already there was a case going on there in Housing Court that Judge Winnick was hearing, and the attorney for the landlord broke into an amazing whine. It was, it just sort of took me back, and I was getting ready to think, now if I were him, I would jump across that bench and get in his face and say, stop whining. But instead, he exercised great patience, listened to the whine, and then reacted to it in an appropriate way by taking into account the things that were important in it and ignoring the things that weren't. And so I guess after all these years of watching him practice and seeing him on the bench, that's the kind of judge that he is. So knowing that that's the kind of judge you will appear in front of in housing court, I think should be should soothe you, any nerves that you have and any concern that you will be listened to patiently and treated with respect, unlike if I had been a judge.
Or else you've just enabled them to whine.
Also speaking today is Katie Ward from Mintz-Levin, who is a volunteer, a regular volunteer at the Boston Housing Court, and also the co-chair of the pro bono committee of the real estate section that oversees the project. So if you have any questions, do you want to be interrupted with questions, or you want them to hold to the end?
feel free to interrupt. If it's starting to become a little bit too unwieldy, then I'll set some parameters. But right now, if something comes up in something I'm talking about, raise your hand, happy to address it. Frankly, interacting is a lot more fun than lecturing, and I also think that it's a lot more educational. So in fact, feel free.
The training is being recorded, so when you ask a question, we will try to remember to repeat back the question that you're asking so that it will be preserved. This recording will then be on the Volunteer Lawyers Project website library, so you'll be able to watch it again should you choose to do so. So I guess, one more housekeeping issue. If your name is on the list outside the door, please put an X by your name. If it's not on the list, please sign up giving us a legible email address so that we can contact you. Thanks.
Do you want to, how do you want to?
You're first.
I'm first.
First and most.
All right. Maybe at some point we take a break, we can do it. All right, good afternoon. As I said, my name is Jeff Winnick. I'm the first justice of the Housing Court. I've been on the court for, I believe, in my 17th year, and I was a professor at Boston University Law School for a number of years before that, with a short period in private practice. What I want to do today is try to give you an overview of what you need to do to have some possibility of success when you come into the court. Now, I have to assume, and you can tell me if I'm wrong, that most of you are fairly new lawyers, meaning from 1 to 5 years, and within a range, probably not a significant amount of trial or courtroom experience. You may have been in courtrooms, second seating somebody, but in terms of actually being responsible, being the first chair, needing to make immediate, instinctive decisions, not significantly experienced. If I'm wrong, then this can be a very long 2.5 to 3 hours, but I'll operate under that assumption. First, I want to tell you a few things. What you are doing and what you are about to embark on is going to be perhaps the most interesting work that you're going to have done in a number of years. It is you're going to find it unexpected. You're going to find challenges that you had not anticipated. You are going to find rewards that are incalculable. You're going to be representing people who have nowhere else to turn. If you cannot help them navigate through the system, significant likelihood that these people will end up homeless, or at least much worse off than they were 2 weeks ago, 3 weeks ago, 4 weeks ago. They are looking to you for advice, for counsel, probably sometimes for a miracle. It's also the case. And what you need to understand is that at rock bottom, what you are doing is offering professional counsel, professional advice, and not the promise of a happy solution, not the guarantee of a resolution that will meet your client's needs as your clients see it. You're going to help them to navigate, and you're going to find that, and it's been my experience, that cases that have been where there have been VLP involvement, the results for your clients are almost uniformly better than that client would have done without you. You're going to win some cases, you're going to lose some cases. You're going to prevail on some motions, you're going to get adverse orders from some of your motions. That is the nature of the practice. Remember that you are advocating for a client with individual specific problems. You are not advocating for a cause. You are not going to write all of the world's wrongs, all of the common law wrongs that might exist through your eyes in any given case. You need to focus on what your client wants. And that means at a very early stage in this process, you need to find out what it is your client wants. You'd be amazed at how many people forget to ask the client that question. The lawyer comes in talking, and the lawyer predetermines what it is the client will want through the lawyer's lens and not through the client's lens. You may be looking at a case that you think is going to go to the SJC, and what your client wants is 3 weeks because they're planning to move to Alabama. You need to find this out. The other thing that you need to remember and know in this system is that the other side is not the enemy. The other side is typically going to be a lawyer representing a client, either a property owner or a property management company that is simply trying to operate their business and do their job as they see best. And there may be a disagreement. Maybe a disagreement factually. You may have disagreements in terms of interpretation of the law. You may have differing assessments as to likelihood of success or prevailing. But your job in this process is to offer your client your arm's length, dispassionate view and representation. Be careful not to take things personally. It doesn't mean that you can't create a good working relationship with your client, but it's task specific. And frankly, you're going to be negotiating quite intensely with the representatives for the other side. It's a lot easier to negotiate and advocate when you're talking to someone who is willing to listen to you. People tend to be willing to listen to you when you do not assault them from the first 5 seconds that you meet them. I think, just as a introduction, sometimes the first time you meet the other side in the housing court, the best thing you can do is just get the other side to talk. How do you see the problem? What is it your client is looking for? Get information about what it is that the other side wants before you've tipped your hat as to anything that your client wants. You may find, first of all, lawyers like to talk. So you may find that you're getting free discovery because the lawyer tells you a lot more about the case than you had anticipated. Second, your expectations going into this discussion may shift dramatically if you hear the lawyer say to you, well, we'd be happy to let the tenant stay if, as opposed to, we want your client out and we want your client out in 2 weeks. If you haven't taken the time to find out, you won't know that what the plaintiff wants is very different than what your client may want. And for this discussion, let me just say, I'm going to be assuming that for the most part, you're going to be representing tenants in the housing court. The VLP program provides representation for both sides. But the far and away the most, the lawyers who are doing representation are representing tenants. So if there's something that comes up that deals with the landlord side, I will reflect on it. So keep your ears open, get the other side talking, and then you can start to formulate either a strategy or a framework for the discussions. Other thing I'm going to assume is that you don't know how courtrooms work, or at least you don't know how the housing court works. And every court is different. The clerk's offices are different. The clerks in the courtrooms are different. The judges all have different personalities. And you simply need to find out. And what that means is that if you find yourself in the court on a given day, try to find some time to sit in and just watch. Watch what the judge does. Get to know some of the clerks, ask questions. How do you do this? How do you do that? It's just a practical way to get yourself better centered. If you know that you're going to be doing a trial, try to see if you can find some time to watch a trial in the court that you are going to be in. You get an idea of whether the judge wants you to ask to come forward to show a witness a document, or are you free to roam around in the courtroom? Does the judge want opening statements, or does the judge want you to waive opening statements? Does the judge like exhibits marked in a certain way? These are things that you simply can find out either by observing or asking one of the court personnel or another lawyer. Joanna is a perfect resource. She's there because she has enough experience that she'll be able to know how the judges in the court would prefer things, and she might be able to tell you what you should avoid trying to do. So don't hesitate. By the way, I don't think it was mentioned at the beginning, but it was earlier this week. Joanna was honored with some other women lawyers as the top women's lawyer in Massachusetts by Lawyers Weekly, and it's a reward and award that's well deserved. So you'd be asking one of the top lawyers in Massachusetts. Now, what I want to do today is talk to you then about how to go about preparing and presenting a case in the housing court. I'm not going to cover everything. I have this, I think you probably all have the slides, and I have the slides that just give me they're more from my memory than yours for talking points, but it might assist you just to make sure you dot the I's, cross the T's. Appearance in court. As I said, I'm assuming that most of you are not experienced trial lawyers, and that one of the benefits for doing this program is it will give you an opportunity to represent the client, stand up and talk in a courtroom, either on motion or at a trial. And I can't guarantee that you are all going to have trial experiences. One of the interesting reactions to the Lawyer in the Day program over the many years it's been here is that when you enter a case, the other side starts to take that case very seriously and wants to engage you in settlement discussions. So just by your presence, you have already changed the tilt of the playing field. You've at least come closer to making it even, but sometimes you've tilted it in favor of the tenant just by your mere appearance, and you need to understand that. Don't get cocky. It doesn't mean that you've won the case, but it means that the other side wants to treat the case seriously. So that's just a insight to know. I presume no prior experience when you come into my court. What I expect from you is that you will be prepared, that you will have at least thought through the factual and the legal issues, and that when you stand up to talk to me, that you can say succinctly what it is you want me to do and why I should do it. I've always believed that the art of motion practice, if not trial practice, is the art of being able to engage the judge in a conversation, albeit a formal conversation, and also albeit with a conversation that the judge ultimately can control. But nonetheless, I want you to talk to me and engage me. Tell me simply, what is it you want me to do and why, and then sit down. If I'm curious or I'm uncertain, I will ask questions. And it's something I almost always do. If you have a prepared outline or some written paragraph for your motion, I can guarantee you will be 3 words into that handwritten presentation before I have cut you off and started to focus the conversation. Work from notes, but engage. Engage the judge in eye contact and listen. If the judge asks a question, even if it wasn't on your list of topics to cover, answer the question. If you don't know the answer, don't fake it. It's okay to tell the judge, Judge, I hadn't anticipated or thought through that question. If you give me a 24 hours, I can get you a response or a short memo on it if it's something that you hadn't, if you hadn't anticipated. But don't try to trick the judge. The judge won't be tricked. The judge will know that you don't know. And most judges don't ask you questions with the intent of trying to trip you up or trick you. Judges ask questions because it's something that they think would be helpful to them, the answer to resolve the question, to resolve the issue that's before the judge. So be flexible, listen, and if the judge says something that you think is absolutely wrong, rarely happens, but with some courtesy and respect, push back. Judge, I don't know that that analysis is correct in light of, and then go on and talk. The worst that's going to happen, if it's someone like me, is I'm going to start to engage you in a discussion, back and forth. But if what you say makes sense to me, you will have caught my attention and you'll start me thinking, and I do change my mind. There are times when I sit there and say, I was wrong. I usually say it to myself. But then I will go back and I will fix whatever it is that I had thought through. So don't be afraid to engage the judge. Having said that, you have to know when the judge is finished and stop. Usually when the judge says the motion is denied, at that point is when the discussion should stop. Don't stand up and say, but, and try to reopen the motion hearing. The judge doesn't want you to do that. And the other little practice tip, judges hate motions for reconsideration. It's not as if we didn't think about it the first time. If you have something absolutely new based upon facts that could not have been anticipated at the time of the hearing, raise it on a motion for reconsideration. Or if the judge, in the judge's order, just gets something absolutely wrong that you were sure was stated differently at the hearing, and you're absolutely sure that it was the judge has it factually wrong based upon what was said at the hearing, you file a motion for reconsideration. But don't do it as a normal and regular part of your practice. In terms of trial, I expect you to have some working knowledge of the rules of evidence, but I don't expect you to be F. Lee Bailey type practitioners with the ability to just smoothly put in and lay a foundation for every document that you can think of, a business record or a photograph, or lay a foundation for experts' opinion. You're in the process now of learning to be trial lawyers. It's going to take you a lifetime to develop the skill set to do that well. I don't care how good you get. You're still going to be in the process of evolving to become better. But at this point, you have to start sometime, and I can't think of a better environment than trying a case in the housing court. First, you have judges who are used to seeing law students and new lawyers come into the court. And you have judges who take their obligation to teach seriously. And I do think that to some extent judges aren't there just to decide cases, but they have a responsibility to teach the lawyers who come into the court how to try cases, at least in their courtroom. So you can prepare for much of your trial by simply thinking through in advance, not only what it is that you have to prove, but also what is it that the other side has to prove. Because sometimes your best case is going to be preventing the other side from proving an element of their case. In a simple eviction case, if a landlord needs to prove service of a legally sufficient notice to quit, and the landlord hasn't served it in hand, or hasn't had a constable serve it in hand, at least you have the elements, perhaps, of a defense that you can start to cobble together. But you have to think that through. And you have to think through, what is it the landlord's going to do to prove it? What objections can you make? Or what evidence ought you to present by way of testimony to put into doubt whether the landlord has met its burden of proof on that issue? That's just by way of a simple example. If you thought that through before you step into the courtroom, you can then start to prepare strategies, how you're going to present it. And I've always believed that it's important to have as strong a working knowledge of your opponent's case as it is to have an understanding of yours. And it's just for that reason. It will help you see the weaknesses in the other side's case, and it'll help you see the weaknesses in your case. If you ask yourself a simple question, if you're representing a tenant, you ask this question: if I was representing the landlord, how would I go about attacking my defense or defending against my counterclaims? And just prepare the other side's case. One, you are going to see weaknesses in your case, so you can think about how you may be able to present some additional evidence to shore up a weakness or mask a weakness if that's what it is, or to deflect the judge's attention away from the weaker part to the stronger part of your case. But if you haven't thought it through before you walk into the courtroom, I can tell you, you will not think of it while you're sitting at counsel table. Because trying a case is like juggling 5 balls and keeping them all up in the air at the same time. It's wondrous to behold when you can do it, but you have to anticipate that 1 or 2 of those balls at any given time are going to be bouncing, and you're going to be struggling trying to get them back up into the air. The less time you spend doing that, the better, and that's preparation. The other thing I want you to know about trying a case in the housing court is that if you try to lay a foundation or frame a proper question to a witness and the other side objects, I typically ask the lawyer, what are the grounds for your objection? Which often results in a stutter because the lawyer can't really articulate what the lawyer's objection was. And then the lawyer will say something like, I'll withdraw, Judge. Or the lawyer will articulate the objection, and then I'm likely to, after I sustain, or if I sustain the objection, I'm likely to give you some direction as to what you need to do to overcome the sustained objection. Counsel, you haven't laid enough of a foundation to establish that this was a record that was kept in the regular course of this company's business. Now, if you've listened to me, that will be the next question you ask the witness. And they'll answer yes. You'll then offer the document again, and I will overrule the objection if the objection is made. The other thing you should know about trial practice is sometimes the lawyers are thinking about the next question or their next witness. So they'll make an objection. I'll sustain the objection. The lawyer is so pleased with themselves that the objection was sustained that they don't listen to your next question, which is the same question that the lawyer had just objected to and I sustained the objection, no objection the second time, and in comes the information. Do not ask the identical question, because I will probably say sustained even if there is no objection. But if you try to change it, but still getting to the same point, I'll just sit back and wait for the other side to do their job. So don't give up simply because an objection is sustained. Listen to the judge, see if the judge gives you some direction, and even if the judge doesn't, try to figure out what it is that you did wrong and try to fix it. Judges tend to reward that effort. And one, if they think that you're actually trying to follow their direction, they're pleased that you're doing it. And another way to get your evidence in. But it's a training process for you, and the idea is to keep listening. A corollary to that is listen to what the witness says. Be amazed how many times lawyer asks a question, was the light, what color was the light? Anticipating that the witness is going to say it was green. And you've asked the question, you're looking at your next question, the witness says it was red. And you just ask the next question. You have to be focused on the examination. Again, the best way to think of it is you were having a conversation with the witness. On direct examination, you want it to be a witness-focused conversation. So the judge is not hearing from you, but is hearing the words of the witness. If it's cross-examination, you really want it to be a lawyer-focused examination. You want the witness saying nothing but yes or no, and all of the information is coming from the lawyer without being too obnoxious about it. The other thing in terms of trial practice, and this comes with, I'm sure all of you have had trial training through your different various firms, and that you're talking about putting together a trial book. And trial books are a wonderful way to prepare for trial, breaking out the examinations, the evidence. This allows you to see if you in fact have asked questions sufficient to establish each element of your prima facie case, either affirmatively or for defense. And there's nothing wrong with just having a pencil or a pen and checking it off when you've gotten the information that you want. And before you sit down with a witness, or before you rest your case, if it's multiple witnesses, just go back to your trial book and make sure you've put in evidence on all of the elements of your case. Don't forget about damages. If you have a counterclaim, or you have or if the other side is trying to put on a case for money damages, you can have the strongest case in the world on breach of warranty. You can establish the defects. You can establish they were material. You can establish that the landlord knew or should have known about them. You can establish the landlord did nothing. But if you don't put in evidence on diminished value, or if it's a tort, on the elements of damage for personal injury, you're not going to prevail. So don't forget it, and don't minimize it. It shouldn't be the afterthought of your presentation for trial. At the end of a half hour of testimony, you ask one question about damages. Damages should be an important part of your case. You should think about ways to get the client to articulate what the injury or damage is. I'll come back to it in the evidence portion, but a tenant or a landlord can give a lay opinion as to fair rental value of property, either fair rental value free of defects or fair rental value given its defective condition. The fact that they have no experience goes to the weight, not to the admissibility of that opinion testimony. So, now, what I have, let me stop there for just a second and find out if just in terms of the general role of the court and coming into a court. Any questions that anybody has? Okay. Then let me move on to the rules. You are going to get a case when it comes into the housing court. Typically, it's going to be the day that the tenant is there, either on a trial or there's a motion to issue execution. Now, if it's a motion to issue execution, means that there's already been a trial date, there was an agreement, and the landlord's claiming the tenant has breached that agreement. You may find that you're going to have an evidentiary hearing that day on the motion. Most motions are argued by the lawyers or by the pro se litigants. But sometimes I need to hear evidence. So if in fact you have to decide when you get a motion to issue execution whether it's one that requires evidence or one that you believe can be decided by the judge based upon what the judge already knows or what's there either in affidavit form or otherwise attached to the motion or attached to something that you were providing to the judge. Don't hesitate to ask the judge for an evidentiary hearing if you think it's necessary. The worst that can happen is the judge says no, I will decide it based on the papers, and you can argue if you wish. But at least try to frame the case the way you'd prefer to have it framed if you can. If you don't ask the judge isn't going to just assume that you want it. Most of my discussion now is going to be about trials and what you need to know. Now, there are rules that apply to summary process cases, uniform rules of summary process. I'm not going to go through every one. You have the notes. I strongly encourage all of you to read the notes, the rules, before you come into court so you understand what the procedural tools there may be in your toolbox. And you may find that you can gain some significant advantage by reference to the rules, or, stated differently, the other side's noncompliance with the rules. Or if you want me to consider something, why I can do so within the four corners of the rules. So simply read them. Service and entry. You're going to see a summary process, summons and complaint prepared by the landlord. In summary process, the system works a little bit differently. The landlord comes into court, pays $5, gets a summons and complaint, takes it home, fills it out. The landlord picks the trial date. The landlord, and everything flows from backwards from that. Take a look at the summary process, summons complaint has to be served on the tenant no earlier than 30 days before the trial date and no later than 7 days before the trial date. So take a look at is it 7? Yeah, I think so. Take a look at the summons and complaint and take a look not just at what's written on the face of the summons and complaint, but take a look at the return of service. You can have a summons and complaint that has a entry date that's on the right-hand corner. And the entry date's the last date that the landlord has to enter the case, bring it to the clerk's office, pay the entry fee. It has to be done after it's been served on the tenant. The entry date is the Monday before that's at least a week before the scheduled trial date. So usually a 10-day period, entry date to trial date. Take a look at the return of service. Find out when the summons and complaint was actually served on the tenant. Then take a look at the dates and find out whether it was served within the time period set forth in the rules. See whether it was entered timely. And also take a look at what the return of service says. If your client says that he or she never received the summons and complaint, you're going to find that one usually when the tenant's coming to you on a motion to vacate default judgment because they didn't show up on the trial date. But nonetheless, if the tenant says, I didn't get it, take a look at the return and find out if, in fact, there may be some ambiguity or uncertainty in the service, and that may give you a possible defense. Late filings, late entry of a summary process summons complaint, even if the clerk's office accepts it, is not permitted without the assent of the tenant. So if you have a case where the landlord didn't enter the case until the Tuesday before the trial date, a week before the trial date, and the entry date was the Monday, assuming for a moment the clerk's office doesn't pick it up, you have a basis for a motion to dismiss it's basically for want of jurisdiction, because the plaintiff had no right to enter the case. You can talk to your client about assenting to late filing if, one, you think that is going to result in a settlement anyway, or two, your client doesn't want to come back to court in 3 weeks or 4 weeks, again, when the landlord serves a new summons complaint. But it's something that you should know about and at least talk to your client about. Take a look at the face of the summary process complaint. Upper right-hand corner, you're going to see the entry date. Make sure that the entry date and the trial date, which is in the body, in the middle, fall within the requirements, the time period of the rules. Take a look at well, let me ask you this. Well, we'll do it this way. Take a look at the entry date, the trial date, and then take a look at the box in the bottom where it says notice to each defendant. I could earn a very good living getting $1 for every time the date that's in the middle of the summons complaint and the date that's in the box are different. If they are different, and you pick up a case at the motion to vacate default stage, you have almost a perfect argument, an unbeatable argument to vacate the default on due process grounds. Because by the landlord's old hands, they gave the wrong date, or they gave inconsistent dates. So take a look at it. Likewise, tenants have to file under the rules their answer and discovery counterclaims by the Monday before the trial date, and that's set forth in the bottom also. If your client didn't file it, and the date in that box is wrong, that may give you an argument to ask the court for a right to seek discovery or file an amended or a late answer. Because again, the landlord gave the tenant incorrect information. Second thing you should know is that if the tenant does file an answer and that includes discovery by the Monday before the trial date, by rule, the case is continued automatically for 2 weeks. So it will be 2 Thursdays from the date that's in the summary process, summons and complaint. Now sometimes you are going to find that you get the case on the trial date, it's been 2 weeks, kicked over for 2 weeks, and the landlord hasn't given any answers to the discovery. Now the rules say that a tenant needs to file a motion to compel within 5 days from the date that the discovery is due. If the discovery is served on the Monday and the landlord has 10 days to file an answer to the discovery, you've almost brought yourself to the next continued trial date. Not quite there, but very, very close to it. And then if you count 5 days from the 10, you don't quite make it to the trial date. So technically, your client has not complied with the rules of procedure if they haven't already filed a motion to compel before the continued trial date. But you should still point out to the judge that discovery was requested and discovery was not received, because while the rules tell you what you can and can't do, the judge has some discretion as to how to apply those rules. The worst thing the judge can tell you is, your client's too late, I'm not going to entertain a motion to compel. But more often than not, the judge will simply ask the lawyer representing the landlord, if it is a lawyer, did you get the discovery? Yeah, but my client was slow getting back answers from me, and I can get it to him. In which case, I would likely issue an order compelling the landlord to serve the answers and continue the trial for a week or 2 weeks. But if you don't ask me, then we're just going to swear the witnesses in and proceed with the trial. You should read the statutes, familiarize yourself with the statutes that deal with residential housing. That's Chapter 186, Section 1 et al. You'll see it in 186 sections 9, 10, 14, 15, 18. I'm not going to talk substantively about the different defenses and causes of action, but read the statutes, read the case law that are part of the annotations. Not every case, but you can take a look at and just sort of get a sense of which ones may give you a feel for the various statutes. Also read Chapter 239, specifically Chapter 239, Section 5, that deals with appeals, 2A, which deals with retaliation defenses, 8A, which is the misnomered rent withholding statute, and just and go through to the chapters dealing with stays of execution. Just read through and familiarize yourselves. That is your the substance that you are going to be working with. Now, there's lots of case law that has interpreted these statutes or confused the statutes depending on how you read them, but that's going to be your building blocks that you're going to work with. And for you to be able to make a credible argument in negotiation with the other side, you need to be conversant with the law and with the elements. Counterclaims are not compulsory in the summary process. A tenant, unlike other civil cases, does not waive their right to bring claims in a subsequent action if they don't bring them in an eviction action. But they can't cherry pick. You can't pick one conditions-related claim, a counterclaim in summary process, and then bring let's say, a breach of warranty claim in as a defense in summary process, and a 186 Section 14 claim separately. If you've brought a counterclaim in summary process, then you have to bring all other claims arising out of those same operative facts. So that's something just to consider. I know the VLP does not yet sit in all the district courts in the city, though they are sitting in the BMC in some type of cases, but not eviction cases, I don't believe. There is a statute, it's Chapter 185, Section C, Section 20. It's the transfer statute. A tenant has, or anybody who has a case that directly or indirectly involves residential habitation, meaning within the jurisdiction of the housing court, may transfer a case from the district court to the housing court at any time up until the day of trial, right? Technically, the day before trial. It's not just the defendant's right. The plaintiff who files the case in the district court can transfer it to the housing court. So depending on when you get a case, and not every case you get is necessarily going to be on the morning that you're in the housing court. It may be that Joanna may contact you with a case that comes across her desk that was filed in a district court. Be aware of the transfer statute, because to the extent that you want to bring it into the housing court, you can get it there. Just make sure that if you are going to file the transfer forms, you get them not just in the district court, you have to file in the housing court, and you have to give a copy to the other side. So 2 courts, 1 other litigant, you have to get copies of the transfer. And make sure you get it to them before the trial date, even if you have to messenger it. I'm sure Joanna will pick up the tab for the messenger. If you file a counterclaim, or your client has filed a counterclaim in a summary process case, the landlord is not required to file an answer to the counterclaim. They have the right, they can defend it, but they're not obligated to file a pleading. Some landlord attorneys will, because they want to assert certain affirmative defenses that otherwise they can't argue if they haven't pleaded them. So you may get it, but it's not required. Is it better practice to file answers to them? My colleagues and I sort of debate this. If I was representing a landlord in a summary process case and I got what I thought were substantial counterclaims, I'd at least confer with my client and give my client the option. I know it costs more money to do it, but there may be benefits to filing a written answer. If for no other reason, it may help to frame the upcoming negotiation. And as I said, you can specifically raise certain affirmative defenses that you might want well, if I was the landlord's attorney, I'd want you to be thinking about or worrying about tactically. Motions, the rules say that motions need to be filed no later than the Monday before the original trial date. So if the entry date is day 1, the trial is day 10, the motions need to be filed by day 7, and they're supposed to be marked up for the at the time of the original trial. This almost never happens in the court. Motions get filed, post-judgment motions, like motions for execution, obviously cannot fall within that time, those time ranges. So those get marked up by the clerk. But what happens is the clerk tends to mark up any motions that are filed, including the pretrial motions. And they try to mark them for the morning of the trial, but sometimes they do, sometimes they don't. If you have a motion that you actually had filed on the Monday before the trial date, not only would it not be marked up, but there's a better than even chance that the pleading did not make it into the file, that it's in the inbox down in the clerk's office waiting to be docketed. So what you need to do is find out from your client whether your client filed any motions and when they filed them. If they don't have a copy, but the client remembers going to the clerk's office to file them, ask the clerk if you can see the file in the session, if the clerk is not too busy, or go down to the clerk's office on the third floor and ask whether there have been any papers filed in this case, so that you can find out. If your client hasn't filed motions, but you think that there are motions that should be filed, Joanna has a whole range of pre-printed motions that you can sort of check the box if need be. It's not artful, but it is sometimes the best that you can do. And what you do is when you come into the court and you make either your special appearance or an appearance, you ask the judge if you can present some motions. The judge will always say, I'll take a look at them. I'll certainly let you present them to the judge, and I'll look at them. Always make sure you have copies to give to the other side. To the extent that you know you're going to be filing motions on the morning of the trial, as a matter of simple courtesy, get them in the hands of the lawyer representing the other side as soon as you can, rather than just dumping them on the table in the courtroom. Simple courtesy to do it. Sometimes I understand that you got the case 5 minutes before you're coming into the court. I understand that. And then if this is the first time you can give it to the other side, because you haven't seen the other side before then, understandable. But try to think about how you would like to be treated if you were representing the other side. Now, you should understand that almost all of those motions that you're presenting to me on the morning of trial are not timely. So what you have to be ready to do is have a good argument, be it has to be semi-equitable because you don't have a legal right to this anymore, some good reason why I should allow what you've asked me to do. If it's discovery, and I hate late discovery motions, but sometimes if you can make an argument that it's important because there's information that is uniquely within the control of the landlord that it's critical that you know in order to defend this case. For example, if it's a cause eviction and all the witnesses are employees of the landlord, in order to defend your client from this cause allegation, you need to know what those witnesses are going to say. I may say, no, you can't do it. But the more persuasive argument you make, and the more that I'm convinced that it's fundamentally fair to let you have it, even if it causes a 2-week delay in the trial, I'll do it. But I have to balance your needs against the interests of the other side. And frankly, if I'm looking at an unrepresented landlord sitting next to you, that's going to have an impact on how much I'm going to expect that unrepresented landlord to provide to you. But again, my understanding is in most instances, when you enter an appearance, you're entering an appearance on behalf of a tenant who in fact is facing a represented landlord. Far more often than not. But just be aware of that. Read Rule 6 for the other issues pertaining to motions, and just think through when you have to deviate or ask the court to deviate. The court, at bottom line, is very practical. We're going to try to do what's right, what's fair to both sides. And I'm not going to stand on ceremony, but I also am not going to allow discovery when you ask a question, who owns the property, how long have you owned it? I'm not going to waste my time on late file discovery for things like that. Read the rules of Rule 7 when it comes to discovery. No depositions as of right. I rarely will allow depositions except sometimes in cause cases where it's witness specific as to events that transpired. Most cases I don't. I'll allow interrogatories. Those usually can get you all the information that you need, together with supporting documentation. A practice tip. If you file request for production of documents and the landlord's attorney offers you the opportunity to view the entire tenant file in the lawyer's office or at the management office, as opposed to them just copying the file and sending it over to you, again, within the confines of your time constraints, go and take a look at the file and make sure you're getting everything that you've asked for. There is a tenant file. There may also be a maintenance file. There also may be a correspondence file. So what you need to do is find out what files there may be that has information that is specifically involves or may contain information about your client, and make sure that you are provided with all of those. Forcing the landlord's attorney, if there's a document that is potentially privileged, for the lawyer to identify that document the way that you've always done it, with a privilege log to be able to support it. But always take the advantage of going and see the file, because you don't want the lawyer for the other side making the judgments as to what should be copied and sent over to you. The other problem is sometimes the photocopies are terrible, and you can't read everything that's on a document. And if you see something in the original, when you're reading the file, it gets copied at the lawyer's office and you can't read it, you can either ask for a better copy or take hand notes so you know what that document says. Take advantage of that opportunity. There are nuggets of gold you'll find in those files, sometimes. When you come in and file a motion on the day of trial asking for a leave to file a late answer, I'm almost always going to allow it, even if you've asserted counterclaims. I will offer and I almost always deny your request for late discovery on the day of trial. Again, if you can make a good faith argument to me, some cogent argument, maybe you can move me for focused, limited discovery, but typically not. The landlord in that situation then has an option. You don't have an automatic right to a continuance, except for a standing rule that I'll come back to, that the landlord can say, I'll give them the choice. You can try the case today, or in light of the fact that you just got this answer with counterclaims, I'll continue the case for a week or two to give you a chance to prepare. Landlord's choice. The one caveat to that is that if you are working through the auspices of the Volunteer Lawyers Program and you have agreed to take the case, not just as a limited appearance, but to file an appearance and accept full representation, I have a standing order in which I will grant you a continuance to give you time to prepare. It's 2 weeks to prepare. What I typically do is schedule a telephonic conference between you and the lawyer who you have entered an appearance, and the lawyer on the other side, rather than dragging you down to court, but just to talk to you. And if you've done this before the trial date, I will then try to get a sense of what you need. At that conference, telephonic conference, that would be the time when you ask me for leave to file discovery or file an answer, and I'll set some deadlines. If this takes place before the trial, I'm likely to give you discovery, focused, and the ability to answer. But that's your time to ask, to tell me what it is you believe you need to properly prepare this case for trial. So be creative. if there's something that you want, something you need, ask me. And the worst I can do is say no to you. Jury trials. Very simply, I get lots of jury trial demands. The reason I get them in summary process is that a lot of the unrepresented tenants go to the Greater Boston Legal Services clinics that they run, and they have their forms, and there's a box that says jury claim. They're told to check the box. Why? Not because they know how to present a case to a jury. They uniformly do not know how to present a case to a jury. But they are told that the case will not go forward on the trial date. So they're building in some extra time. I know that, the other judges know that, but if once a jury trial is claimed, what you need to know is that it has to remain a jury trial unless both sides assent to jury waiver. So if you've taken a case that has a jury demand, you have to have a conversation with your client as to whether they want it to go jury or jury waived. And you're also going to, if they decide they want to go jury waived, you're going to have a conversation with the attorney representing the landlord. But if you get a case and there's a jury trial demand on the day that you get it, you should understand the likelihood that case is going to try on that Thursday is remote. I have on occasion, much to the shock of some of the parties, told them to come back on the next Monday, and I will impanel a jury. What happens in that situation is by that Monday morning, the parties have waived the jury and have gone to mediation, and then if they can't resolve it, there's a bench trial that is scheduled. But don't be shocked if the judge says, okay, be back here on Monday or a week Monday. You have no constitutional right to a 2 to 3 month delay in getting your case to trial simply because your client checked the jury box. Equitable relief, covered by Rule 9 of the summary process rules. You're going to be dealing with that either if you get a case in default posture or post-judgment issues where you're seeking Rule 60 type relief, where you're seeing a stay of execution. It could be a civil action filed for a TRO. All I can tell you is that do not believe that there is that you cannot ask for some type of equitable relief. You're limited only by your own creativity and what you think the judge is going to consider to be fair and reasonable. And I say that because it's true objectively, but it's also important to understand tactically. If you come in before a judge seeking equitable relief on behalf of a client who may not have much of a legal leg to stand on, you need to be very careful to frame your request as narrowly as you can, keeping in mind that you don't want the judge to think that this is going to be cause harm to the other side, and you don't want the judge to think you're asking for too much, it's unreasonable. Because reason, fairness, are the two words that are involved in every equitable consideration. In the housing court, when I get equitable relief, if I had to focus on reasonable likelihood of prevailing on the merits, one of the elements for injunctive relief, almost every request that comes before me would be rejected out of hand. So the fact that your client may not have the strongest of claims on the merits doesn't mean that you shouldn't try to frame a request for relief focusing on the equitable. Sometimes you're asking for some time to get your client to an agency or to get your client into a shelter, or more time because an agency had made a promise but they haven't fulfilled that promise, or a medical emergency hit your client or a member of your client's family. So, and understand that whatever it is that highlights the equitable nature of the relief you're asking, have some facts, have some proof to back it up. If your client's in the hospital, get something from the hospital. Get an affidavit. If you can't get an affidavit, get a letter. Get something from the provider. But think about that. Defaults. Again, on Thursday, if you're covering the table and you get a case, very often you're going to get cases where the tenant came late the last Thursday or the Thursday before, or didn't show up on that Thursday, and they come in on the Friday or the Monday, or they get a 48-hour notice saying that they're going to, the constable's coming, and they file the motion, sometimes for TRO, civil action, together with a motion to vacate default judgment. They never file the motions in accordance with Rule 10. Never. Because if you read Rule 10, you can only file a motion to vacate default up until the judgment is entered. And in a default, on a Thursday, the clerk enters the judgment the next morning. So if you're going to be a stickler for the rules, the tenant has between the time that the clerk calls the default on Thursday until 10 a.m. on Friday to file a technically perfect motion to vacate default. If I get a motion to default that's filed after, which is 99% of the motions, I simply will consider them more as if it was a motion under Rule 60. Now, but I'm still using the default standards for looking at it. You have to have a darn good reason why your client didn't come into court, and you have to have some colorable issue to present on the merits of the case if I was going to vacate the default and return it to trial. If your client didn't come to court for a perfectly good reason, but the claim is that they owe $10,000 in unpaid rent, and they say, yeah, I didn't pay it, and you don't have anything else, I'm not going to vacate that default because there's nothing to try. So what you have to do is package both credible reason for not coming in, and I'm pretty loose and flexible on what those reasons are. The dog ate my summons sometimes will suffice, depending. But what's really important is what it is that the tenant would assert if I were to give them the opportunity to testify and present evidence. That's what you want to focus on. But I was being a little bit flippant. Don't minimize the first part. The tenant didn't come to court because they had tickets to a movie that they didn't want to miss. Not going to move the judge too much. So, but think about both. Also, it doesn't hurt to ask the other side before you come into the court whether they assent to vacating the default. And if they're going to do it, think through that the landlord may want some conditions attached to vacating the motion, assenting to vacating the default. And you should also understand if you come in on a motion to vacate default, the judge is likely to attach some conditions. And the conditions may require the tenant to pay the unpaid rent into court, or at least to pay that month's rent, or to do something. So if it's a monetary case, talk to your client before you've come into court to find out the realistic parameters of what your client might be able to do or not do. If your client does not have the funds, don't try to fudge it. If the judge says no, I want to condition this on the payment of rent into court, don't sit there and make the argument, Judge, given the facts of this case, that's not fair. Tell the judge, Judge, the tenant doesn't have the funds, but he does have a defense that if he prevails would greatly diminish the value of what's owed to a point that he could comply with it. Judges don't like to deprive people of their day in court simply because they don't have adequate funds. So the judge will try to do something that's fair to both sides. So think about it. Relief from judgment motion. Technically, you could bring a Rule 60 motion up until a year after judgment enters. Typically, where I see this is the parties enter into an agreement for judgment in January, by which the tenant has agreed to vacate in October. Hear from neither side for 9 months, and then in the last month of the agreement, the tenant comes in on a Rule 60 motion to vacate the judgment, even though it was an agreement that they signed on to. Very rare that those motions will be allowed. So if you get it, if you have a client who asks you to do that, you're going to have to focus on something either that was an unanticipated change in circumstances or something that was misrepresented at the negotiation or at the time that the agreement was entered into. That would give you some legal basis to argue for relief. Appeals. If you're taking a case, typically you're retained through trial. I believe that's what your retainer agreement provides, and that you don't have an obligation post-judgment. But it is important that your clients understand that there are very strict time limits that govern post-judgment actions. 10 days to file a motion for Rule 59, and that would toll the appeal period. But otherwise, they'd have to file a notice of appeal within 10 days from the date that judgment enters, not 10 days from the date they receive the judgment. The judgment is mailed. You should advise your clients, especially if you are not going to be representing them, that they should check with the clerk the next week to find out whether judgment has entered, rather than waiting for the judgment to come in the mail. If they get it, you can tell them to wait till the Wednesday or Thursday, but sometime within that 10-day period measured from the date of the trial, they should check with the clerk if they have not received the written decision. Make sure your clients, if you're on the limited, make sure your clients have filed an appearance after the trial so that the clerk will know to send the decision to your client. Usually, if you tried the case, they're going to send the decision to you, but if you're no longer representing your client, you don't want the decision to fall through the cracks. So just be thinking about it, making sure that your clients know. Bond hearings, I'm not going to just read the statute for bonds. If you get a bond motion, there are two things the tenant needs to prove to get the bond waived. They have to show that they are indigent within the meaning of Chapter 261, Section 27A through G, and they have to show that they have a non-frivolous issue to raise on appeal. And you need to present both. Even if the judge were to waive the bond requirement, the statute still requires the court to make as part of the bond order that the tenant prospectively has to pay their rent for use and occupation. So just be aware of the two provisions. Landlord is not required to file a bond if they take an appeal. And in cases where tenant does not prevail, wants to appeal, but possession is no longer at issue because the tenant is vacated, but there's still dollar issues, legal claims that the tenant wants to pursue. If possession is moot, the tenant doesn't have to file a bond. Executions. Executions in summary process are statutorily limited. Let me say one other thing about appeals. A trial judge does not have the authority to extend the 10-day appeal period in summary process. So even if the tenant has a compelling reason why they missed the appeal, if it's outside the 10 days, the court can't extend it. Other thing you need to look at and be aware of is if the tenant files on day 8 after judgment a motion for a new trial, Rule 59, and the notice of appeal. That notice of appeal is a nullity because the appeal period does not begin to run until after the judge acts on the Rule 59 order, motion, and issues an order. If it's denied, it's from that day that the 10-day appeal period runs. I've had situations where a tenant has filed a notice of appeal with the Rule 59 motion and then doesn't get, it loses the Rule 59 motion and doesn't file another notice of appeal. They're out of luck. So be aware. Stays of execution. The court has discretion, and sometimes you're going to have no defense to a case, but nonetheless, you have something to argue. If it's a case where the tenant is not at fault, simple termination of a tenancy at will, termination of a Section 8 tenancy because the landlord needs the apartment for family reasons, landlord selling the property, so that the tenant is not at fault. You can ask for a stay of execution of up to 6 months in all such cases, and if the tenant is either disabled, handicapped, or 60 years of age or older, up to a year. That may give you, in a case with no other identifiable defenses, some significant leverage if you're talking to the other side or presenting the case to the judge. You may stipulate to the prima facie case of possession and want to put in evidence or argue for the stay. And that's still important advocacy. And the art is to identify and articulate what your client needs and why they need the time, and be mindful of the fact that the court has to balance that against the impact that the stay would have on the landlord. If the landlord is a mom and pop that owns a 3-decker, they're approaching retirement, and they have the apartment, the house, under a P&S with a closing date of X. And if I give them, the tenant, 6 months or a year, the mom and pop are going to lose the sale and may, in fact, lose the house because they can't afford to carry it anymore. Those are the type of things that I need to balance. Creatively, what can you consider? You can consider things like asking questions to the other side. Would the bank consider, or would the buyer consider, extending the closing date if they knew that there was a judgment for possession that would provide them with the apartment by a date certain? The landlord's attorney is going to usually hem and haw, but if you sit there and say, would you at least ask and inquire? Typically, they would. Just may give you some wiggle room. something to work with. But you have to think about asking for it. But again, don't focus solely on your client's needs. Think about what the other side's needs are going to be, and how do you account for those needs when you're making your argument to the judge or you're making your presentation to the landlord's attorney. That's the art of what you're doing for that. Executions itself in possession, and this, you may have cases like it. A landlord first off, a execution for possession is only good for 3 months from the time that it issues. Landlord has to levy within 3 months. Now, that time can be told if there's a written agreement between the landlord and the tenant post-judgment, post-issuance of execution, where the landlord has agreed to give the tenant more time. So if the landlord agrees to give the tenant 2 months, then that execution can be used for another 2 months beyond the 90 days. But the problem for you is that the executions that issue from the court have a line at the bottom that says this execution cannot be used after X date. It's usually going to be the 90 days from the time it issues. So what either the landlord needs to do is come back into court and ask for the court to reissue the execution. And if it's beyond that 90 days and there was no stay, it's too late. The landlord can't do it. The execution is stale. Even if the landlord prevailed in court, if it goes beyond 90 days and there was no tolling or stay, and the landlord comes in the 91st day and says, can you reissue the execution? I can't. I don't have the authority to do that. If it was told, and the landlord comes in after the 90 days, but within the 90 days taking into account the tolling, the extra 2 months, then I can recall and reissue. So you need to look at those documents and look at a calendar very carefully, both if you're a landlord, to make sure that you don't, if you're representing a landlord, so you don't find that your client has lost their judgment for possession because they didn't levy, or if you're representing the tenant, to find out whether in fact the landlord still has rights under the terms of that execution. I'm not going to spend a lot of time with it, but the other thing to look at if you're in a levy situation where there's some period of time has gone by, make a determination as to whether there has been something that the landlord has done from which you could argue may give rise to a reinstatement of the tenancy or a creation of a new tenancy. Typically, that would happen is there was a judgment. The landlord accepts a rent and even an increased rent from the tenant. If the tenant pays it and the landlord doesn't reserve, you arguably can present to the court a claim that there's a new tenancy. It's hard to establish because waiver is ultimately factual. Typically you have to show that either that was the intent of the parties or that from the circumstances waiver should be presumed. But again, look for it. Before I go into the promulgation for possession, questions? We're about halfway through the session. This is going fine. Yes?
If an execution, if the 90 days